He got busted for using their department-issued cell phones to send personal texts, some sexually explicit. Now their case has climbed all the way to the Supreme Court. Will this set a precedent that it could affect all of us? What do you think? Should personal messages at work be private, or do employers have the right to snoop? It's their property. Call in, 1-877-TEL-HLN is the number. Joining us, Stephen Viscusi, radio talk show host and author of the book, Bulletproof Your Job. Also with us, Dan Eaton, an employment law attorney. Guys, thanks for being with us again. Call in your thoughts on this. 1-877-TEL-HLN is the number. Stephen, let me start with you. How much privacy should we expect at the workplace?
Mike, we should expect zero privacy at the workplace when we're dealing with our company's computer or texting. If that company is paying for your BlackBerry, they own it. And in the case of the cops, the guy's a cheater. He's cheating on his wife and he's cheating on his company. And I know for a fact that the Supreme Court is going to explain to him that they don't care about his cheating on his wife, but you can't steal messages from your company that belong to it. So he's a cheater and an idiot.
Call in on that, see if you agree with Stephen, 1-877-TEL-HLN. Stephen, let me stay with you and I'll get Dan in. I send a message to my wife. Should I expect the company, maybe they've looked at it, and I should know that?
Well, let me be very clear. When I send a message to my wife or partner on my personal BlackBerry, that's my business. But when I'm sending a message to my wife or partner on a BlackBerry or an iPhone or the new Google phone that was given to me and being paid for by my company, much like my computer, it's my company's business. Let's put it this way. It's like keeping your resume on your boss's computer. And this is a great topic, not only for you. I'd love to talk to Joy Behar about this on her news show, and Nancy Grace. Can you imagine that duel?
There you go. Well, Dan, okay, let's talk about this legally, Dan. Where does a company cross a line and they're no longer monitoring, they're snooping? Or is it like Stephen says, that's never the case?
It's their property.
Go, Dan, your thoughts.
Well, the question, Mike, I can't be quite as categorical as Steve was, but really the critical question that the court will confront is whether this cop had a reasonable expectation of privacy in his text. Now, the facts are really not quite as clear as perhaps some of the earlier comments would suggest. Specifically, the City of Ontario Police Department had a policy that said emails are subject to review.
Right.
But this particular officer's supervisor, one of his supervisors, a lieutenant, said to him that he had sort of an informal policy that, look, we are not going to review your text if you are willing to pay for any kind of messages over the 25,000 characters that the department is allotted. So the question is whether that gave the officer a reasonable expectation of privacy in those texts, including the large number of texts that were personal. In fact, when they did this audit in August of 2002, it was very interesting that only 57 of the 450 texts that they reviewed were actually work-related. But nonetheless, the question is whether the informal policy that the lieutenant said to the officer that, look...
Mike, let's say this way. I don't mean to interrupt you, and I'm not an attorney. I'm just a workplace expert. I talk about this in my book. I have an entire chapter in Bulletproof Your Job dedicated to in-house texting. This is a SWAT team member, a SWAT team, protecting security, cheating on his wife. He's not writing to his wife like you talked about. He's writing to his lover on his, allegedly, on his workplace instrument. So this is, he's a total idiot.
But what does that have to do with
on his wife on his work computer? How stupid can you be?
Dan, go ahead.
What does
he's
that
not Tiger Woods. Tiger Woods at least allegedly cheated on his wife and paid for his own taxes. This is a guy letting the City of Ontario pay for his affair. It's a disgrace.
Tiger's name and folks. Dan, go ahead.
I get the outrage, but the question that the court, the 9 members of the Supreme Court will have to address is whether he had a reasonable expectation of privacy in what at least the 9th Circuit said were the mixed messages he was receiving from the City of Ontario.
Well, these are verbal alleged. These are not standard operating procedures.
Hey, Steve, let me get out the policy and we'll take a quick break. Here's the policy as we've seen it here. The formal policy reserving the right to monitor network activity, including email and internet use, that allows light personal communications. But I believe the policy says employees should be cautioned. They have no expectation of privacy. Dan,
that's what the policy says.
Won't that
cheat on your
trump
wife
any kind of verbal?
On the internet?
Well, that's really the critical question, whether the lieutenant gave, in fact, his officer a reasonable expectation of privacy by saying, yeah, I know what the formal policy says, which, by the way, didn't specifically refer to text messaging, but I will informally not review it if you pay for text over $25,000.
Guys, let's take a quick break. We'll take your calls. Stay with us. Back to Prime News on HLN. We're talking about privacy in the workplace and how much privacy you should expect. The Supreme Court has agreed to take up a case out of California regarding text messages on a company phone. Joining me once again, Steve Viscusi, radio talk show host, author of the book Bulletproof Your Job, employment expert. Also with us, Dan Eaton, employment law attorney. So two experts ready to take your calls. 1-877-TEL-HLN. Again, the number. All right, before the break, we read the formal policy. Dan, shouldn't that end it? If in a formal written policy, in the last sentence or last part of the sentence says they should have no expectation of privacy, shouldn't that end it? And you think the Supreme Court, it'll make their job pretty simple if they go that way?
Look, I normally represent employers, so I would say yes. If there aren't mixed messages coming from a subordinate like the lieutenant who said, yeah, but we aren't going to look at it if you pay for the text above a certain amount. That's really what interested, I suspect,
to your mistress? But this is to your mistress we're talking about.
Why does that matter? You keep focusing on that, even bringing in Tiger Woods. I don't see why that matters. It doesn't matter what the content is. The question is whether it's mistress or private matters or anything.
We just have different moral values, you and I. I think it's inappropriate.
Come on. We're talking about the law here.
Well, I'm talking about morality, and morality and the law to me are one and the same.
The Supreme Court is going to look at this wonderful document called the United States Constitution and the Fourth Amendment that protects you against unreasonable searches. That's what they're going to be looking at, and the law is they're going to take a very strong look at this, I suspect.
Let's talk about how this could affect all of us, Steve. I mean, will employers just get tougher on this and just say, hey, at that first orientation, here's your company cell phone, no personal business,
not only will
period.
They, but let me point this out. That
it might already be.
Someone who's using their texting for cheating on their wife is so distracted from their job because the wife is texting, the mistress is checking, and it can happen to men or women. So it's not just the morality issue that I happen to personally believe in, but it's a common sense issue that a good worker cannot work and concentrate while he's involved in multiple affairs.
Yeah,
or and personal, I think it's just common sense.
Yeah, or personal business, period. Let's get a call in.
Would you keep your work resume on your boss's computer?
No,
What's the difference?
A lot of people do.
Well, nobody that I know, nobody that watches my show, the Headhunter from Hell does.
Let's get Betty in on this. Betty in Arkansas, go ahead.
Hi, I was just going to say, I think that as long as the company's paying for the cell phone or the computer, that they have a right to know what's being said. That a short call, like to call and say, I'm on my way home, or something like that to your, like my husband calls me and says, I'm on my way home, or when he's out of town, I got in my hotel room. I think that's okay, but once you get past that, then you don't have any expectation of privacy.
Right on for you, Betty. You're 100% right.
Yeah, but Steve, can a company get in trouble if they don't monitor in a uniform fashion? In other words, well, we're going to take a look at your text, but we're not going to take a look at Dan's.
Well, listen, I'm not a lawyer like Dan, so I can't speak to that question, but I can say this. It's just common sense that since the employer has unequivocally right to looking at their own equipment that they're paying for, why would you be so foolish enough as to put your writing to your lover and cheating or looking for other jobs or putting your resume on? It's just common sense. And Bulletproof Your Job in the book, I have an entire chapter dedicated to it.
Dan, real quick on that front.
Sure. We can agree on the common sense point, but really the question is the law and the Fourth Amendment. And by the way, we're talking about a government employer here, and the Fourth Amendment applies to them. California is one of the few states where the right to privacy also applies to private employers. So when you talk about how broadly it could apply, it depends. It's certainly going to shape the rights of the 10% of America that lives here.
Spirited discussion. We got to run. Steve, Dan, we appreciate coming up. We've mentioned him. Tiger Woods. Is he seeing one of his mistresses again?